Hello. Okay, we are now going to talk about mens rea. So first of all, what is mens rea? Well, it's the mental element of a crime. Remember, to be guilty of a crime, you have to have the actus reus, the physical act, and you have to have the mens rea, the mental act. And there are different types of mens rea. When you look at an act of parliament, if you see words like maliciously, dishonestly, recklessly, knowingly, intentionally, those are all forms of mens rea. If you don't have the mens rea, most crimes you cannot be guilty of. So let's look at the most serious type of mens rea. That is intention. Intention is split into two types: direct intention, so that's what you really want to do, and indirect intention. I always use the example of a pilot and somebody wants to murder the pilot. So they put a bomb underneath the pilot's seat. The bomb goes off and the plane explodes. Direct intention. The defendant directly intended to kill the pilot. That's murder. However, all the other passengers, 300 of them maybe, died. That could be an example of indirect intention, because when you place that bomb under the pilot's seat, you probably did think, hang on a minute, everyone else is going to die or be seriously injured. So therefore, that could be indirect intention. Now, Mohan defines direct intention as a decision to bring about the prohibited consequence. Motive is not the same as intention, so you could have a very good motive, but if you decide to bring about the end result, then the prohibited consequence, you have got direct intention. Indirect intention, this is slightly different. The defendant's aim was not the prohibited consequence. Indirect intention is linked to the foresight of consequences. Section 8 of the Criminal Justice Act 1967 says a jury must consider all the evidence in deciding whether the defendant has intention or not. Current law comes from the case of Woolen. This is the man who threw his baby into the pram, except the baby hit the wall and died. So the point of law for indirect intention, Woolen, if the defendant foresees death or serious injury, GBH, as virtually certain, this can be indirect intention. Now, the next type of mens rea, that's a lower level than intention, is subjective recklessness. This is where the defendant foresees a risk of the consequence, but goes ahead and takes that risk. The type of recklessness that we look at in law is subjective recklessness. This is from the defendant's point of view. We don't care what a reasonable man thought. We are looking at, did the defendant foresee a risk of the end result, but decide to go ahead and take that risk? And subjective recklessness was established in a case called Cunningham. So Cunningham, he tore the gas meter off the wall and the gas leaked and harmed the neighbour. He was not guilty because he had not foreseen the risk of harm. Cunningham also said any time you see the word maliciously in an act of parliament, it means intentionally or subjectively recklessly. Crimes containing subjective recklessness that are particularly relevant for what we study: assault, battery, Section 47 ABH, Section 20 GBH, and these are called basic intent crimes. For example, Section 20 GBH, the defendant maliciously wounds or inflicts GBH. What is meant by maliciously? Well, it's intentionally or subjectively reckless. Cunningham was confirmed in 2003 in the case of GNR, where the House of Lords unanimously said you have to use subjective recklessness in every crime where recklessness appears. And this crime was criminal damage. The two boys set fire, they set fire to some newspapers, left them burning when they ran away from home at the co-op, and then it caused over £1 million of damage because the fire spread to a wheelie bin, and that spread to the co-op. And in the House of Lords, which is now called the Supreme Court, they decided that the boys had not foreseen any damage, therefore they were not guilty. So the next type of mens rea that you should just be aware of is negligence. You don't need to know very much about negligence. I think it's unlikely you would be asked a question just about negligence. So negligence is where the defendant fails to meet the standards of a reasonable person. This is an objective test. So it's a much lower fault level than intention or recklessness. The example probably that's applicable to your studies is gross negligence manslaughter. So did the defendant in Pitwood, for example, did he fail to meet the standard of a reasonably competent railway gatekeeper? And I think the answer is yes, he did. Okay, tune in for the next video on strict liability.